Good afternoon, everyone. Welcome to Shumaker's Spring Employment Law Seminar. As with everything with COVID, nothing is easy, so we had some technical difficulties on our end, but we are ready to get started and proceed. For those of you who haven't met me before, my name is Jan Pietrusca. I'm the chair of Shumaker's Florida Employment Law Group. We're going to do some brief introductions, get some logistics out of the way, and we'll go ahead and get started. For those of you who don't know Shumaker, Lupin, Kendrick, we are an AmLaw top 200 law firm. We have offices in Tampa, Sarasota, Charlotte, Charleston, Toledo, Columbus, Ohio, Bloomfield Hills, Michigan, and our newest office, Greenville, South Carolina. Shumaker prides ourselves on being a business law firm. We can handle anything that a business needs: corporate, real estate, healthcare, litigation, and of course us, the labor and employment group. We're here to assist you with every issue you have with your employees, from hiring through firing. We also have fully staffed immigration and employee benefits groups to assist. We spend half our day counseling clients on how to avoid issues, and then the other half of the day litigating issues that couldn't be avoided. The unofficial motto of our department is we're better than Geico. A 20-minute call with us can save you a lawsuit. I'm joined today by my partners, Brad DeBobian, Chris Cavalieri, and John Burgess. As always, we have way too much information and too little time. There is a chat function. We ask people to pre-submit questions if possible. We'll also be looking at the chat function and trying to answer questions at the end, time permitting. We usually go over, we're scheduled from noon to 2 today. If you need to leave early, we understand. We are recording this presentation, so if something happens or you have to leave early, just email Katie at the RSV email that you used and you can get a recorded copy. In addition to the topics that are on the invite, the COVID vaccination, reasonable accommodation, and employee objection issues, at the end, John Burgess, our employee benefits attorney, is going to come on and talk about the COBRA premium subsidies that are in the new stimulus bill and give you a brief summary of what that is. We have received HR and Florida Bar CLE credit for this seminar, and Katie afterwards will email all the attendees the numbers so you can get credit. We, again, here are online. You know, things are getting better and improving, and so we're trying to figure out, will we remain as a webinar? Will we go back to in person? I anticipate that in the near future, I'm going to send out a questionnaire about this seminar process. We always seek feedback from you about how we can do better. And so we're going to look for input from you about, do you prefer the online version or in person? How long works for your schedule and format and other issues? So please give us any feedback that you can, so we can make this better for everyone. With that said, we're going to go ahead and get started. And first up is Brad DeBobian.
Thank you, Jan, and good afternoon, everyone. My name is Brad DeBobian. I'm a partner in Shumaker's Tampa office in the Labor and Employment Practice Group. I'm here today to talk mostly about vaccinations for employees and the related considerations for employers. What we can do by way of requiring vaccinations, what we maybe should do, and why those two things aren't necessarily one and the same. So with that, we'll get started. If we could advance 2 slides, please. As a framework for the discussion today, I'm going to talk through 4 common vaccination questions that we've heard and gotten a lot in the last few months as vaccines have become more widely available. Those questions are: 1, can an employer require employees to get the vaccine? 2, are there circumstances in which an employee may be excused from a vaccination requirement? 3, what if an employee refuses to get vaccinated and doesn't fit within one of those legal exceptions? Could we fire that person? And then 4, and kind of the ultimate question, well, is there an alternative to requiring vaccination that we might be better off with, such as incentivizing or simply encouraging the vaccine amongst our employees rather than requiring it outright? So with those as our backdrop, we'll kind of walk through and get you some guidance on these topics. But before we dig into the questions, I want to make a couple of background points just to sort of set the table a little bit. The main federal regulatory agency that's sort of speaking to the vaccination in the workplace questions is the EEOC, which of course oversees federal anti-discrimination law. And we have some guidance from the EEOC at this time, but not sort of the definitive guidance that in a perfect world we would have and be able to share with you. Vaccines in the workplace, also something you might think, well, OSHA, may weigh in on that. That organization certainly kept a low profile on COVID issues during President Trump's administration. Since taking office in January, President Biden has issued an executive order directing OSHA to step up its guidance and enforcement of employers in connection with all things COVID, and that is beginning to roll out, but still don't have a ton in the way of definitive things to relay to you from OSHA on vaccination. One of the reasons that the vaccination question is a complicated one is because it touches on some level kind of every hot button issue in the employment space. There's FLSA and compensation issues with respect to non-exempt employees and time spent getting a vaccine, particularly if the employer, requires vaccination. There's potential workers' comp issues if the person, heaven forbid, has an adverse reaction, over and above just sort of the standard day or two of feeling a little lousy. We've got FMLA and potential implications, Americans with Disabilities Act implications. The Genetic Information Non-Discrimination Act comes into play in terms of the information that's solicited in connection with the vaccination. So it's just kind of the smorgasbord of employment law issues, and that's what makes this sort of a little bit of a hairy subject. And of course, like so many things COVID related over the last year, a lot of these are just still a gray area and likely will be for some time because we haven't had the opportunity for the courts to kind of flesh out issues and give definitive rulings on things. But all that being said, I'm going to offer you, our best thinking on the topic of vaccination, where we think the law is or may be headed. So with that, let's get started. And next slide, please. The first question, hey, can an employer require employees to get the vaccine? Generally speaking, the answer to that question is yes, right? Most employees are known as at will, meaning that the employer or the employee can terminate the relationship at any time and for any non-discriminatory reason. And so on that basis, employers really have a lot of latitude to set the terms and conditions of employment and say, if you want to keep your job, you'll abide by these policies and procedures, one of which may be a vaccine requirement for employees. On top of that, we do have some recent guidance from the EEOC, which sort of strongly suggests that in their view, an employer requirement of vaccination for employees is okay. So, as an initial matter on this threshold question, can employers require it? The general answer is yes, but I want to make a couple of footnotes before we move on. One of them is the fact that all of the currently available COVID-19 vaccines are emergency use authorization approvals by the FDA, which is different from sort of full and final approval like a vaccine might get after multiple years of testing and vetting by the FDA. And in light of that, I want to make you aware there's a case in federal court in New Mexico whereby an employee has argued that his employer required him to get the vaccine, but didn't give him a fair warning of the negative repercussions that would happen to his employment if he didn't get the vaccine. And because this is an emergency use authorization vaccine, not a fully approved one, that failure on the part of the employer was a no-no, and consequently, he's been damaged by virtue of the penalties and punishments he suffered as an employee for not getting vaccinated. So that case is still working its way through the court, and it's a public employer. The plaintiff in that case is a corrections officer at a prison. So maybe a basis to distinguish there between the public and the private sector. But the emergency use use authorization statute does have a requirement generally that you need to make an employee or anybody you're going to require to get the vaccine aware of the negative consequence that may happen to them if they don't get it. In this case, the employer says, we gave him warning. We let him know if he didn't get the vaccine, there would be discipline. You know, that's an issue of fact for the court to decide, but I wanted to bring you aware of that pending case. The other thing I want to talk about briefly at this juncture is the vaccine passport concept, right? So here in Florida, earlier this month, in April, Governor DeSantis signed an executive order which prohibits businesses from requiring that patrons and customers show proof of vaccination to either enter the business or receive goods or services from that business. And any businesses which violate this executive order may be penalized by the state and by being ineligible for contracts or grants funded through state revenue. So there are some teeth in this, particularly if it's a business that receives state contracts or other state funding. So the question then presented is, well, does this preclude us from requiring employees to be vaccinated? And I think the answer is no. The plain language of the executive order just applies to patrons and customers. And doesn't say anything about employees. So we think on that basis, this executive order does not impair an employer's ability to require its employees to get the vaccination. So although the answer to our first question is mandatory vaccination by an employer may be possible, what we're going to ultimately explore is whether or not it's a good idea to require it on a mandatory basis. And we'll unpack that a little bit in the coming slides. Next slide, please. If an employer requires vaccination of its employees, are there some circumstances in which an employee may be excused from that vaccination requirement? And the answer here is yes. There are two main bases upon which an employee can be excused from having to get vaccinated. Both arise under federal anti-discrimination law. The first would be if the employee has a disability, as that term is defined under the Americans with Disabilities Act, which really is to say that they have a health condition that precludes them from safely receiving the COVID-19 vaccine. The second way that an employee might avoid a mandatory vaccination would be if they have a sincerely held religious belief, practice, or observance which would preclude them from using or receiving the vaccine, in which case the employee would be protected by the federal law called Title VII, which would prohibits discrimination on the basis of religion. So that analysis in and of itself is a little nuanced, and you may be familiar with it from accommodation questions and issues in other contexts, and Jan's going to sort of speak to that in greater detail in his presentation on the topic of accommodations generally. But in the context of vaccinations, I want to just point out, the fact that somebody claims they have a disability or they claim they have a religious observance or affiliation which precludes them from getting the vaccine is not the end of the analysis. Really, it's sort of the beginning, because first we have the question of, okay, well, is this a legitimate claim to disability or religious affiliation? And there, of course, are a limited subset of questions that we can ask as an employer to get at the heart of that question. And then if the answer is yes, this person does have a legitimate disability or a legitimate religious affiliation. And then we've got the question of, okay, is there a reasonable accommodation for this employee that we can make available to them whereby they can not be vaccinated but still do their job in a manner that doesn't pose an undue hardship to the employer, that doesn't threaten the health and welfare of others in the workplace or customers. And so the analysis really gets complicated if we take that hard line and say we're going to require vaccinations. You inevitably open the can of worms where we have to deal and grapple with the need for potential accommodation in certain circumstances and what we can do with that. So that's one of the reasons that we think it probably makes sense to stop short of requiring vaccination, because then you don't sort of find yourself having to wrestle with those difficult questions. Next slide, please. All right, what if we go ahead though, we require vaccination, but we've got an employee who just refuses to get vaccinated, but doesn't fit within one of the two exceptions that we just discussed, either the disability exception or the religious affiliation exception? Could we fire that person if they just say, hey, I don't have a disability or a religious reason, I just am not comfortable, I don't want to get this thing? So the answer to that question is probably yes, you could fire that person. If an employer has a policy that says all employees need to get vaccinated and a person just doesn't want to do it and doesn't claim a legally protected basis for excusing themselves, then that is probably grounds for discipline up to and including termination. But this gets to sort of the heart of the question of whether employers really want to take that hard line and say we're requiring vaccination, or might we achieve substantially the same objective if we stop short of an outright requirement and merely encourage or even potentially incentivize the vaccine rather than requiring it outright. And the rationale here is that everything you hear and see and anecdotally that I hear in talking to people is there's still a significant percentage of the population, by some estimates 30 or 40%, of people who are saying, hey, I'm not really comfortable with the vaccine. I don't want to be on the sort of early edge of getting it, despite the fact millions and millions of people have been administered seemingly without too much negative repercussion. But there's just still a lot we don't know in terms of timing. And so you've got a big chunk of the population now that vaccines are widely available who are just saying, I get it, it's out there, but I'm not ready to go there right now. So the question for employers is, hey, if the number's 30 or 40% of the general populace that just doesn't want to get a vaccine at this point, if we as the employer take the hard line and say everybody has to get vaccinated, no questions asked, are we going to find ourselves between a rock and a hard place if that percentage bears out and really 30 or 40% of people just don't want to do it? It's almost a lose-lose proposition in a couple of ways. On the one hand, you've got the employee morale question. You're putting to your employees the personal, the very personal issue of are they comfortable with the vaccine, and now you're tying their livelihood to doing something that they really might not be comfortable doing in their personal life. And then on the other side of the coin, the business is in a difficult spot, because if we take the position that, hey, we're going to terminate people if they don't get vaccinated, if those percentages bear out and it's really a 30 or 40% of folks who don't want to do it and aren't going to do it, depending on the size of your workforce, obviously, but that could be a significant number of people that, maybe being laid off, and then you got to deal with that whole business interruption and trying to replace those folks. So another reason that we think the hard line of, yes, we're requiring vaccination is probably not where employers want to find themselves on this issue. Next slide, please. So is it a better idea then to encourage or even to incentivize employee vaccination rather than to require it outright? And the answer here probably is yes. And the reasons, I've just gone over two of the biggest ones. There are some additionals, but we don't have to deal with the reasonable accommodation question and navigating the interactive process and whether or not we can reasonably accommodate those folks who have disabilities under the ADA that are protected, or the religious affiliation. And two, we don't have to take this hard line and then deal with layoffs, potentially a significant number of layoffs of employees who may just be uncomfortable with vaccination and don't want to get vaccinated at this time. So we think stopping short and encouraging or potentially incentivizing is the way to go. But what incentive, we have to be a little bit careful in terms of the incentives that we roll out. And so part of the incentive analysis got a lot simpler with the recent passage of the American Rescue Plan Act, which I'm going to talk about in some detail over the next couple of slides. But that really is applicable to employers who have 500 or more employees, 500 or fewer employees. It would be the same group that was subject to the Families First Coronavirus Response Act, and we're going to talk about that in some more detail. For those of you who are with larger employers that have more than 500 employees, the incentive question is complicated by a couple of factors, and I'll just touch on them briefly here. One, it can be considered, and a vaccine incentive may be considered part of a wellness plan, which is a regulated sort of space, and the incentive in that case can't be so substantial as to appear coercive. Now, of course, do we have any guidance from the authorities on what amount, say, if you're going to offer a financial incentive, is or is not deemed coercive? We don't. We just know that there's sort of a potential landmine there, and that whatever amount is offered needs to be de minimis, so as not to be viewed as being coercive to participation in a health plan, which of course is the whole point, right? We're incentivizing it because we want people to take the action and do something that they may not otherwise be inclined to do. So there's a little bit of tension there. We also need to potentially still address those reasonable accommodation issues, even if we just incentivize it, right? Because we're offering a benefit in the form of an incentive to get the vaccine. What about those people who have legally protected reasons why they can't get the vaccine? They have the disability, they have the religious affiliation. Are they precluded then from getting the benefit of that additional incentive? Do we need to accommodate them and offer them the incentive for perhaps taking some other alternative action that's not getting vaccinated? There's a number of issues that present with the incentives for larger employers outside of this FFCRA extension, which I'm going to talk about in a minute. So certainly something to work through with council if you're developing an incentive program for vaccination. Next slide, please. But I mentioned the American Rescue Plan Act, which was very recently enacted in March of this year. As of April 1, so just a few weeks ago, employers can again elect to offer those Family vs. Coronavirus Response Act paid leaves for COVID-related issues through September 30th of this year. And you may recall the Family First Coronavirus Response Act was pushed out in March of last year when the coronavirus was sort of just unfolding. It provided emergency paid sick leave, which was up to 80 hours of leave for employees, funded ultimately by the federal government through payroll tax credits for time spent in a mandatory quarantine or to address COVID or COVID-related symptoms. And then it also included the Emergency Family and Medical Leave Act, which was sort of an additional tweak on FMLA, which was up to 12 weeks of paid leave, the first 2 unpaid, but that could dovetail with the emergency paid sick leave, again, funded by the federal government through that tax offset to care for a child whose school or other child care provider was not available because of COVID. So that law was mandatory for employers with 500 or fewer employees through December 31st of 2020. You had to provide those paid leaves. And we counseled many of you on developing leave forms and navigating those waters. That became an optional benefit that employers could offer through March 31st of this year. And then with the American Rescue Plan Act, we've now got a further extension of it through September 30th. We've got a couple of additional tweaks too, though, that make it a really attractive option for helping get employees vaccinated if employers are inclined to do that. So next slide, please. In addition to just extending the option to offer these paid leaves through September 30th of this year, it also there's a bunch of stuff in the law. I'm just going to focus on those things that may pertain to vaccination. So for folks who took emergency paid sick leave, which was that 80 hours of paid leave, that clock is reset as of April 1st of this year. So if a person took all 80 hours prior to March 31st, they get a new 80 hours. And so that clock was reset. In addition, both emergency paid sick leave and the emergency FMLA are both now available for the same qualifying reasons, as well as for 3 additional reasons, 2 of which are tremendously helpful as we employers try and figure out how are we going to navigate the vaccine question. So one of the reasons that a person can now take paid leave, ultimately reimbursed the employer through the payroll tax credit, is if they're getting a COVID vaccine. And a second reason is if they are recovering from any illness, injury, or condition related to the vaccine. So this is a significant development for employers' analysis on the employee vaccination question and what we can do to incentivize it. With the new law, employers can offer paid leave reimbursed by the federal government. So it's not really costing the employer, and it's not asking the employee to burn their own PTO bank to go take time to get these vaccines. Give a half a day for folks to go take the vaccine and give them, whatever time they need. A day or 2 in most cases is what it turns out to be is our anecdotal observation on recovery time or time a person may need out of the office to sort of deal with particularly that second dose. The real major downside here obviously is the potential for abuse, because this is again up to a substantial amount of paid time off that could be utilized for or in connection with obtaining a COVID vaccine. So sort of the biggest challenge for employers will be policing that and making sure that we don't have abuse people saying, oh, I'm in my second week of still feeling bad after my COVID vaccine. I need more paid time off. That's going to be the biggest challenge. Another kind of practice pointer for you all, to the extent that the American Rescue Plan Act wasn't on your radar screen, this is an occasion to update your FFCRA paid leave forms, with these additional bases, so that you can accurately document folks who need to take some time off. Next slide, please. The next couple of questions have to do with potential employer liability in connection with vaccination. Again, pretty speculative at this point because it's very early in the process, but let me tell you what we think on those topics so far. So if an employer requires, encourages, or incentivizes employees to be vaccinated and then somebody gets sick as a result, could the employer be held liable? And I don't mean just the, hey, I feel bad for a couple of days sick. I mean, if they had a truly severe adverse reaction to a vaccine that the employer sort of pushed them in the direction of, whether by requiring it or merely encouraging or incentivizing it, is there a potential for liability there? Potentially there is, but I think there's cause for breathing a sigh of relief, because that's likely a workers' compensation policy. In fact, we have a good case in Florida, not in the COVID context, but in another setting where an employer simply made available a vaccine to its employees. It wasn't even a requirement. Somebody got a vaccine or treatment at the employer, making it available, then they had an adverse reaction, and that was ultimately deemed to be a covered workers' comp claim, even though it was merely optional for the employee to take that vaccine. So that's where we think that we land on the question of adverse reactions. Is there potential liability? Yes, but probably a workers' comp claim. And I'll touch just very briefly in connection with this question on another client alert that we pushed out recently on a law here in Florida, Senate Bill 72, which limits access to the courts for businesses, for plaintiffs who want to bring claims against businesses alleging COVID-related claims. I think that employee claims would also probably be subject to that new law. Any employee who has a claim that's potentially COVID related, including getting a vaccine, that they wish to bring against their employer, would be subject to a heightened pleading standard and the need for a third-party affidavit from a physician before they even have access to the courts. So any non-workers' comp claim, a tort claim or other claim, probably barred by that as well. Let's look at the flip side of the coin, and go to the next slide, please. If the employer, rather than requiring, encouraging, or even incentivizing vaccination, what if the employer just says nothing about the vaccine? Is there any way that employers potentially get burned there by not doing enough to make the workplace safe? And I think that, again, and this is sort of a highly speculative question, but I'll tell you what I think on it at this point. Given the known risks associated with COVID, and given the OSHA general duty clause to provide a place of employment free from recognized hazards causing or likely to cause death or serious injury, it is a good idea to probably have some policy which speaks in some form or fashion to the availability of vaccination. I'm not saying you have to incentivize it. Merely encouraging and letting folks know that it's available probably covers that base, but can we imagine a scenario in which an employer is completely silent on vaccination, and then employees get sick and ultimately want to point the finger at, hey, I contracted this at work and my employer didn't even say anything about people getting vaccinated, even though it was well known that that would sort of help depress the level of infection in the community. Again, we sort of hear and see it all from the plaintiff's bar. So I'm just speculating here, but I could see that claim, and a way to protect yourself in that regard would be to at least have some policy which speaks to the availability of vaccines at this point. Next slide, please. Can we ask employees about vaccination status? So the ADA imposes limits on certain medical inquiries, which may be disability related. There are some other sort of limitations I mentioned, GINA, the Genetic Information Non-Discrimination Act, which is a occasion for concern about what we can or can't ask about. But the EEOC has made clear that simply inquiring whether an employee has been vaccinated or not is not a disability related inquiry and is permitted. The cautionary note for you all is, do not, if a person says, no, I'm not vaccinated, that's not an invitation to open the door of, well, why haven't you been vaccinated? Because now we start to get into a variety of other issues. But it is okay for employers to simply ask the question, are you or aren't you vaccinated, and stop there. Next slide, please. So that sort of brings me to the end. A couple of things I wanted to emphasize. Consider encouraging or even providing some incentive for vaccination, but not necessarily requiring it, because that just presents a whole host of challenges that employers may not want to have to address or deal with. Use education and use the paid leave under the FFCRA to incentivize it if you're an eligible employer for the FFCRA paid leaves, and make a point to update your forms if you're going to do that from whatever you were using prior to April 1 of this year. Be mindful of employees with disability or religious beliefs which preclude them from being vaccinated, especially if you're requiring it or you're going to offer an incentive outside of the FFCRA paid leaves. And check with your work comp carrier. I mentioned the protection that we think is available in the event of an adverse reaction to a vaccine, but make sure that you are on the same page with your carrier about a duty to report and the timing requirements for reporting any injuries in connection with COVID, whether related to the vaccine or COVID more generally. With that, I am done. I appreciate your attention, and I will turn it back over to Jan.
Thanks, Brad. Again, my name is Jan Pietrusca. I'm here to talk to you about disability and religious accommodations. One of the things we're always trying to do with these webinars is sort of look into the future and predict what are going to be the problems or issues that clients are going to face. And in putting together this webinar, we were all sort of in agreement that accommodation requests are likely going to become more prevalent, and they're getting more complicated, not only as to disability accommodation requests, but also religious accommodations that most employers are less familiar with. So we thought this was a good time to do sort of a refresher on generally what's required for accommodations and some best practices. Next slide, please. So when we say accommodation, what we're talking about is under certain laws, specifically Title VII and the Americans with Disabilities Act, and in here in Florida, the Florida Civil Rights Act, employers are required to modify or make changes to their standard practices and policies and requirements based upon religion and or a disability. So we're going to do a quick overview as to which employers are covered, which employees are covered, and then get sort of into the nuts and bolts and best practices. This slide here is probably the easiest one we're going to talk about because what employers are covered under Title VII, the ADA, and the Florida Civil Rights Act is all the same. If you're a private employer and you have 15 or more employees in 20 or more work weeks this year or last year, you are covered under these laws. Now, for our smaller clients out there, if you have less than 15 employees, it doesn't mean you can just put your head down now and go to sleep. You have to realize that there are city and county ordinances out there that cover small employers and provide the same or similar duty to accommodate. Now, that doesn't mean you're going to have to grant the same accommodations as a larger employer. You will have a much more restrictive area of accommodations to be granted, but it doesn't mean you can just ignore the situation and say, I don't have to do this. You probably still have to go through the interactive process that we're going to discuss. Next slide, please. So what employees are covered under the ADA that they can get a disability accommodation? Key takeaways: it's not only your current employees, but applicants. There's no minimum time that someone needs to be employed in order to be eligible for a disability accommodation. We have to accommodate both during employment and during the application process. They also have to have a covered disability, which since the passage of the Americans with Disabilities Accommodation Act took the definition of disability from this to all the way out here. And so there is a much larger definition of who is disabled. As to qualified individual, direct threat, these are concepts that really, as an employer, you're going to use as a defense to an accommodation or an explanation why you can't grant an accommodation. And we're not going to have time in this seminar to go into depth with those, but in the future, if there's interest, we can spend more time on them. Next slide, please. So what employees are covered under Title VII? Again, this is the one that requires you to make accommodations for religious belief or practices. So again, covers both employees and applicants. They need to have a sincerely held religious belief or practice. And again, there's no minimum time for employees to be employed to get the accommodation. Next slide, please. So the key part of the accommodation process is identifying when there has been a request for an accommodation. Generally, under both Title VII and the Americans with Disabilities Act, there is no duty to make an accommodation until it's been requested by the employee, okay? When we're defending accommodation lawsuits, we often find that what happened was a breakdown in the process. And usually that breakdown in the process is a supervisor who had some misperception or hadn't been trained or aware of our process, okay? And so with the misperceptions that we commonly see are a belief that there must be some sort of magic words that have to be invoked. The employee does not have to reference the Americans with Disabilities Act. They don't have to reference Title VII. There's no requirement that the request be in writing. An oral request to a supervisor can initiate the process. The request doesn't have to come from the employee. A family member or someone else can initiate the process. And there's even case law out there that even if we have a reasonable accommodation policy and the employee doesn't comply with it, if they've made a request of management, therefore the company is deemed to have notice of the issue and needs to respond. When we're doing training of supervisors, we normally tell them that anytime an employee indicates there is some conflict with our policies or procedures traceable to a medical condition or a religious issue, then it's time for the supervisor to elevate it to whomever has been tasked with dealing with reasonable accommodation requests. Next slide, please. So once there's been an accommodation request made, the parties are supposed to enter into what's called the interactive process. And we're going to walk through what that means under the ADA and then under Title VII. Generally, the interactive process is an informal process where the employer and employee exchange information and explore what is the issue and come up with a solution. This is just a general sort of overview of what some of the steps should be. Important point to take away from this slide, explore reasonable accommodations, plural. We are not limited to just the accommodation that the employee requested. What an employer is tasked with doing under the law is examining the situation and coming up with a solution if possible. And the law makes clear we, as the employer, can suggest alternative accommodations. We can try things that don't work. Again, it is a process. It is not a one-time decision. Next slide, please. So some sort of best practices for the interactive process. Remember, the interactive process in the ADA provides that we as the employer are entitled to obtain specific information from the employee, not only about the accommodation, but their disability. One of the best defenses for an employer in going through an accommodation lawsuit is that the employee refused to cooperate or refused to provide information that we are entitled to. And so as we work through the interactive process, as the employer, we always want to be very clear about what the process is, what information needs to be provided by the employee, and what the deadlines are. Okay, clear deadlines are very important so we can show that there was a failure in the process caused by the employee. Again, as you can see, we're allowed to not only ask about the accommodation, but also the nature of the disability. And we'll talk a little bit in a second about the medical information that we can seek. Take away from this slide, also look at that last bullet point, how long the accommodation will be needed. This is something that's often missed by clients and the employee or their physician. Case law is clear that how long the disability will last or how long the accommodation will be needed is definitely relevant information. It's something that's often not addressed and can be helpful when we talk about getting medical certification. Next slide, please. So again, the ADA provides, and normally as an employer, we shy away from asking about medical information from an employee. But once they've made a request for an accommodation, that opens up the door and we're allowed to ask for medical information from the employee with two sort of exceptions. First, if the disability or the need for accommodation is obvious, then at that point you can't seek medical certification. So again, an employee in a wheelchair or who's blind, we probably shouldn't send them to the doctor to get a doctor's note saying that they're in a wheelchair or they're blind and need an accommodation. Additionally, if the employee has already provided us all the information we need, we can't make them go through useless steps. And so sometimes we see this where you have employees that start the process of reasonable accommodation by bringing a doctor's note in. And sometimes clients, they have their process and they have their forms, and on sort of autopilot, they just proceed and say, look, you need to go to your doctor. Well, we already have a doctor's note. And ADA and case law say that if the employee already gave us everything we needed, we can't make them go through useless steps. This one is kind of rare because, again, most of the time when you get that doctor's note from the employee, it's not going to address the duration of the disability or the duration of the accommodation. If that information is missing, we should be able to proceed with our certification process. Next slide, please. So again, if the need for the accommodation or disability is not obvious, we can seek medical information. The ADA is clear. We can require medical certification from an appropriate healthcare professional. What does this mean? Well, if an employee is seeking an accommodation because of a heart condition, a letter from their psychologist may not be appropriate medical documentation of the issue. In addition to getting a doctor's note from the employee, the ADA also provides that we can ask questions of the doctor. However, per the EEOC, we should get a release from the employee granting us permission to discuss or question their doctor. The employee's failure or refusal to provide that release can also be a defense used by employers to not grant an accommodation. Here at Shumaker, we've designed sort of standard accommodation forms. If you've worked with us before, you may have seen these, but it's actually two forms. We have an accommodation request form, which is for the employee to fill out, where we document what is the specific accommodation or issue that the employee's identified, and we obtain that release that the EEOC says we need. And then we have a second document that is the medical certification that's given to the physician, where we ask specific questions about the disability, the duration, and the accommodation, and potential alternative accommodations also. Next slide, please. So this slide is we reach the end of the interactive process, all the different ways it can end. First takeaway is accommodation is not guaranteed. There's all sorts of reasons that we may not be able to accommodate an employee. One, they may refuse to participate or provide us information. Two, they may refuse to accept an alternative accommodation we want to try. 3, it could be an undue hardship, and we got a slide coming up in a little bit that'll explain what that is. But what we have to remember is no matter what the accommodation that is requested by the employee, the EEOC says that if you can't grant that accommodation, you as an employer must then consider as an alternative accommodation, do we have an open existing position that the employee could perform with their disability that we can transfer the employee into? And the EEOC's position is that if the employee is qualified for that position, they should automatically get that position. Now, that's the EEOC's position. The EEOC believes that if the disabled employee is qualified, they get it, even if we have a better applicant available. Not all the courts agree with the EEOC. In fact, here in the 11th Circuit, which is our appellate court that governs Florida, Georgia, and Alabama, our 11th Circuit has said that is not a reasonable accommodation. An employer having to accept or transfer the disabled employee into a position rather than a better qualified one is not reasonable. So here in the 11th Circuit, we can choose a better qualified applicant over the disabled employee, but realize that the EEOC has an alternate position. In fact, they just last year, they sued an employer up in Pennsylvania for making a disabled employee interview for the position and sort of compete against other applicants. That employer ended up settling with the EEOC for $100,000. So while case law here in the 11th Circuit seems clear, the EEOC is always looking for cases where they can try to change the law or advance a position, and this is one area that they are focused on. If you're going to choose a better applicant over the disabled employee, you should make sure that the differences are really apparent or obvious. Why is that person so much more qualified than the disabled employee? Next slide, please. So with religious accommodation, we have a similar interactive process. Note no medical certification here, but again, communication with the employee, explore alternative accommodations, select one, and then document what happened. Next slide, please. Can we obtain certification of someone's sincerely held religious belief? The technical answer is yes, you can, but only in very limited circumstances. You need to have an objective basis for questioning either the religious nature or the sincerity of the employee's belief, at which point then you can seek certification. When we handle disability accommodations for employers, we tell employees, because of the very broad definition of disability, the best defense is that the accommodation is not reasonable, not challenging the disability. It is the same analysis with religion, but on steroids. You should enter into this process, for the most part, assuming that it is a sincerely held religious belief or practice. Because again, the definition is so broad. It does not have to be a standard organized religion. The EEOC defines a religious belief as a sincere and meaningful belief which occupies in the life of its possessor a place parallel to that filled by God. So, of course, that's as clear as mud. The non-legal question you should ask is, does the employee have a sincerely held belief about life, the purpose of life, or death? All right. A real world example, going back to COVID and vaccination, there is a case up in Pennsylvania that found that veganism could be a sincerely held religious belief or practice in regards to vaccination, in that employers may have to accommodate it. Okay. And so veganism is not a standard organized religion, but if it's a sincerely held belief by your employee, it may have to be accommodated. Political beliefs are not religion. There's cases out there dealing with the KKK where employees attempted to challenge that was their religious belief, and the court found that's a political belief. Individual personal beliefs are not, and this is where it gets really gray and murky, and what we really end up with is cases at sort of the edges, where something is truly out there. Courts will sometimes take a stand. There's a famous case from the Southern District of Florida where an employee was eating cat food at work, and he claimed that was his religion, and the court found that was just a very odd personal belief, and it was not a religion that needed to be accommodated. So I think there's cases denying that the flying spaghetti monster, if you don't know what that is, Google it, but employees have tried to claim that that is a religion that needed to be accommodated. If you're going to challenge or seek certification, likely the challenge or review you should be doing is it sincerely held by the employee, not the belief or ethos, okay? And I'll give you a good example of where an employer was successful of this. The Waldorf Astoria had an employee show up one day with beard in violation of their no facial hair policy, and the employee claimed, this is my religious belief and I need to wear a beard. The employer attempted to enforce the policy and ended up in litigation, and the Waldorf Astoria won on the basis that it wasn't, even if it was a religious belief, it wasn't sincerely held by the employee. And the reason they won is because this employee had been with them for 14 years and never previously had an issue with the dress code or the beard policy. It just suddenly became an issue. Takeaway from this slide is be very careful in attempting to challenge or certify a religious belief. If you do want to do so, recommend you consult legal counsel. Next slide, please. Undue hardship. So under both the ADA and Title VII, you do not have to grant an accommodation if it is an undue hardship to the employer. But nothing is ever easy, okay? So the term undue hardship has a different definition under the ADA than it does under Title VII. So for a disability accommodation, an undue hardship is something that requires a significant difficulty or expense to the employer. There are lots of case law out there finding that a cost to the employer is not enough for you to claim undue hardship. There's sort of a four-factor test looking at what is the cost, how long it's going to last, what are the revenues available to your business, is there outside funding or grants available to assist with the accommodation, and so again, it has to be significant. For religious accommodation, the standard for undue hardship is anything more than a de minimis cost or difficulty to the employer. This is a much lower standard than what we have under the ADA. Important to remember on undue hardship, it is a very factual case-by-case analysis, and this is a defense that you, the employer, God forbid there's litigation, will have to go prove. You will have the burden of proof of convincing the judge or jury that this was too much of an undue hardship for your business, that you couldn't grant the accommodation. Broad picture, you do not need to grant accommodations under either law that will create a safety issue. So an example here is, you may remember a couple of years ago, Abercrombie & Fitch was sued. They had an applicant come in with Muslim headdress, and the allegation was the employer didn't hire them because that would be in violation of their clean look dress policy. And that was found to be a failure to accommodate a religious issue. In similar vein though, employers that have a pants-only policy in a manufacturing area have one on religious accommodation cases as to employees whose religion requires that they not wear pants but only wear dresses. Courts have found, because of the safety issue with the moving machinery and parts, that the request to wear loose clothing is an undue hardship on the employer. Additionally, neither law requires you to grant an accommodation that would cause you, the employer, to violate the law. So a good example of this is, and if you've ever had to deal with one of these employees or applicants, I feel your pain. There are individuals out there who believe that their social security number or information to the federal government is in violation of their religion, and they object to tax reporting, social security numbers, etc. If you look at the continuum of those cases, early cases, the employees were winning these lawsuits where courts were finding that this was a sincerely held religious belief that needed to be accommodated. Later cases, though, the employers have been successful in establishing that this is an undue hardship because they have a requirement under federal law to report taxes, to report social security numbers, and identify who their employees are, and therefore it's an undue hardship to not comply with those laws. Next slide, please. So a couple of slides here on best practices on dealing with accommodation requests. Even though earlier I told you there's no requirement that the employee comply with your policy, we do recommend that you have an accommodation policy notifying employees that if they need accommodation, we do consider those. Here's who you should report it to. Again, part of getting this right is doing it the same way every time, having a policy, having a process, having standard forms. Training and empowering supervisors is also very important. We don't want a breakdown in process. We don't want a supervisor making a snap decision or saying something dumb that will get us in trouble, okay? For the interactive process for a disability accommodation, we always want to require medical certification. Again, assuming that it's not obvious and they already didn't give us the information, we do want our process to always include the requirement that the employee obtain medical certification. This, again, helps us in that eventually you will end up with an accommodation request that something seems off and you're going to want that medical documentation, and that's easier to do if we do it every time and not just as to that particular employee. Additionally, it sort of sets up a barrier or a threshold. The employee has to actually do some work. They have to go see and find a doctor that will certify that they have this disability and they need this accommodation. Under the ADA, again, we should ensure confidentiality and non-retaliation for seeking accommodation. As to confidentiality, it's our recommendation that you really take this process away from an employee's supervisor and have someone else handle it. We prefer the employee supervisor not to have information about their medical issues or limitations, and if possible, have HR or other management handle it. Consult employment counsel, we're here to help. We do this pretty regularly where it's a pretty quick call to talk about who's the employee, what are their requirements, how have we gone through our process, give you a spot check and at least some peace of mind that we're headed in the right direction. Additionally, we can help you start building some of the defenses that unfortunately some of you might need in litigation. And I'll give a great example of something that we've built into our standard forms. So unpaid leave is a pretty regular request for an accommodation. And under the ADA, unpaid leave, even in addition to FMLA leave that's available or PTO leave that we already provided, can be a reasonable accommodation. However, from case law here in the 11th Circuit, we know that a request by an employee for indefinite unpaid leave is by law unreasonable, meaning we don't have to grant it, okay? But if that's going to be our defense, we start thinking about how do we prove that the employee needed or wanted indefinite unpaid leave. And so instead of your accommodation form saying, please identify how much unpaid leave the employee needs, we've built our form out where it asks that question, but then there's a box, number of days, number of weeks, number of months, unknown, indefinite, right? If this doctor says the employee needs indefinite unpaid leave, we've now gathered the evidence that we need directly from the employee's own doctor to defend our decision not to grant that indefinite unpaid leave. Next slide, please. It wouldn't be an employment law seminar if we didn't tell you document every step of the interactive process. Again, our best defense is going to be that the employee didn't cooperate, didn't participate. We also have to realize that no matter how we end the interactive process, the letter or notice that we're providing to the employee is not only going to the employee, but God forbid we're in litigation, it's also probably going to be our best chance of creating an exhibit to give to the jury that succinctly explains what happened and how this all went wrong, right? And so juries believe paper more than they believe people. And if we have a document that explains that here's how the process started, here's the deadlines we gave to the employee, here's why the process broke down because of the employee, and here's why we're denying the accommodation. All of that now is in writing in a very simple document that a jury is going to look at and hopefully believe. Next slide, please. So at the start, I said we're trying to look forward for you and see what's coming. And we think accommodation requests, because of COVID-19, are going to become more prevalent, right? From Brad's presentation, we already know COVID-19 vaccination, the EOC is telling us that we need to make accommodations. But for those of you that still have employees working from home, when we bring them back, there is a percentage of employees that they don't want to come back, and they're going to be incentivized to do what they can, including make accommodation requests not to return to work. Face masks, we've been dealing with that now for over a year about employees making accommodation requests. I also think business travel, once that gets up and moving again, we're going to get accommodation requests from that. The good news is everything I just told you about the process should apply to these accommodation requests. And if we have a process and a policy, we should be able to deal with it. The bad news is COVID has fundamentally, in many ways, changed the employer and employee relationship. And things that previously were not reasonable accommodations now may be reasonable accommodations. And the reverse, the EEOC's guidance last year during COVID made the point that just because something was a reasonable accommodation when everyone was in the office, now with everyone working remote may not be reasonable anymore. And so we can't, again, be on autopilot and say, well, I know this isn't reasonable because 5 years ago we went through this process with a different employee and I'm comfortable. Things have changed and we just have to pause and think a little bit more. Next slide, please. So as Brad said, the EEOC has issued specific guidance requiring that we accommodate disabilities and sincerely held religious beliefs as to vaccinations. You know, the big question first was, can we require vaccination? And Brad did a very good job explaining that we think you can, and all the issues with requiring it and or incentivizing it, really. But what the EEOC did in its guidance is make clear that we are allowed to have a safety-based qualification standard. So just replace that phrase with vaccination requirement, even if it will screen out individuals with a disability or religious belief, provided that that employee poses a direct threat to others, meaning our coworkers or our customers. Next slide, please. And so the EEOC's guidance, again, made clear that the threat that an unvaccinated individual will expose others to the virus at the work site, again, coworkers or customers, is such a direct threat. Now, what the bad news about all of this was this quote, and I put it in here so you can see it. If that direct threat cannot be reduced to an acceptable level, The employer can exclude the employee from physically entering the workplace, but this does not mean the employer may automatically terminate the worker. So if you remember when we talked up above about the accommodation process, then eventually, if we got to a point where we couldn't accommodate their issue in their job and there wasn't an open and existing position somewhere else, termination is the likely result of that accommodation process. The EEOC seems to be pumping the brakes on that usual rule as to COVID vaccination. The EEOC is saying we can exclude them from the workplace, but not automatically terminate the worker. Next slide, please. What the EEOC said is we must first consider additional alternative accommodations in regards to the unvaccinated employee. And again, some of those are simple, requiring the employee to report to work, but even if everyone else no longer has to wear a mask, they have to, or wear other PPE. Again, temporarily reassigning job duties. And normally under the ADA, you don't have a requirement to take away essential job functions, but here they're suggesting that if it's temporary, you may have to do so. And then look at the last one, work from home. The EEOC has directly identified that as to the unvaccinated employee that has a disability or a religious accommodation issue, we will have to consider continued working from home as a reasonable accommodation. So, that's the bad news here, because to the extent that we're trying to bring our workforce back and we're trying to figure out vaccination, now we're having the EEOC telling us that certain employees who can't get vaccinated, we may, even though everyone else has come back to the office, have to allow those unvaccinated employees to continue to work from home. Now, I still think that there's a requirement that this accommodation be reasonable and not an undue hardship for the employer, and the employee must be able to, while at home, perform the essential functions of their position. So for a factory worker that drives the widget machine, working from home is probably not a reasonable accommodation. But the bad news is, while previously we had this long body of case law that said working from home as an accommodation generally is not reasonable for employees to be productive, they all need to be together in the workplace. It also generally isn't reasonable because the employer doesn't have the equipment or the infrastructure or the informational security to allow some people to work from home and others to work from the office. All of that is gone, right? Employers, unfortunately, just spent a year proving by necessity that employees can work from home. Employers did buy all of the equipment that now allows these employees to work from home, and we did improve our informational security so that a lot of those issues that we could point to previously are gone. Next slide, please. So just some COVID-19 accommodations or best practices. Brad already went over that asking if someone's vaccinated is not a disability-related inquiry, but make sure you stick to just a yes or no question. For those of you that still have a remote workforce, but you're wondering about what percentage of my employees might try to raise a disability issue or maybe a childcare issue, commuting issue, remember the EEOC has a approved questionnaire that you can use to survey your employees about a return to work and what issues they might have in returning. Now, we have to be real careful in using this questionnaire because remember, we're not allowed to make disability-related inquiries, asking someone, do you have a disability? But the EEOC's return to work questionnaire basically bundles all three together and says, will you have some issue with returning to work on this date because of a disability, childcare issue, commute, or other issue? Yes or no? The fact that the employee answers yes doesn't necessarily tell us they have a disability. It tells us they have one of those issues, and therefore the EEOC has approved the use of this questionnaire. This may be an opportunity for you to take that survey and realize, great, I've got 95% of my employees indicating they're gonna have no problem coming back to work. Or I've got 25% of my employees telling me that as of June 1st, there's still gonna be some sort of issue. The EEOC in their guidance way back at the start of COVID also made clear that you as the employer have the right to ask employees to make accommodation requests before that return to work date. Now, the EEOC didn't say you have the right to require, it said you have the right to ask. But again, if we can get 80% of employees putting in a request for a disability accommodation and working through the interactive process ahead of time, instead of that Monday when we expected everyone to be there, that's going to be to our benefit. Best practices, be flexible. Again, there have been significant changes in what is and is not a reasonable accommodation. And just because we did something previously doesn't necessarily mean it's true anymore. Documentation, as always, will set you free. Multi-state employers, remember, not every state is doing COVID differently. There are all sorts of laws as to, say, vaccination. Some states have bills pending right now that employers cannot require vaccination. I forget, I think New York, South Carolina, maybe Minnesota. And again, not all of those laws are going to pass, but it just shows that you can't just say, look, this is the way I do it in Florida. It's probably good in those states. Last, again, stay informed, consult employment law counsel. We're here for you. Not everything is a 2-week project. We can quickly provide some advice on a 15 or 20-minute phone call and give you that peace of mind that you're on the right track and not going to end up in a lawsuit. So I appreciate everyone's time. Chris Cavalieri is going to be up next to sort of talk about employee objections and other issues. So thank you.
Thanks, Jan. Good afternoon, everybody. First of all, on behalf of all of us, thank you so much for taking the time out of your day to spend with us. I know probably by this time of the year, most or maybe all of us are sort of virtualed out. So thank you for devoting this time to us, and we hope that you're finding it useful. So what Jan just talked about was when employees have medical issues and they request certain accommodations, right? And we know that that's going to be a big hot topic as we return to work. And for those of you who have been working the whole time, obviously medical issues during COVID are going to be a big issue that you're going to have to deal with. We also anticipate that as you return to work, or for those of you who have been to work this whole time, as long as this pandemic continues, we also expect that you're going to see a rising level of employees who have concerns about COVID safety in the workplace. Employees who complain to you or to other employees, or God forbid to the public, about your policies having to do with COVID. Sometimes you might have employees who refused to come into work or refuse to accept job assignments due to COVID safety concerns. So that's what my presentation is going to be about. Again, for those of you who don't know me, my name's Chris Cavalieri. I'm a partner here in the Employment Law Group in Tampa. So let's get going. So there are a couple, next slide please, thank you. There are a couple of major laws that deal with non-medical issues where employees are complaining or protesting or refusing to work. And the first one that comes into play is called the National Labor Relations Act. That's the NLRA. For those of you who are not familiar with the NLRA, and maybe some of you might not be, because a lot of us tend to think that the NLRA only applies for unionized companies, companies with unions. That's actually not the case. Section 7 of the NLRA also applies to all private employers when employees are engaging in concerted protected activity. What is that? What that is, and it's right there in that third bullet point. The NLRA protects private employees who are taking action on behalf of or with other employees concerning the terms and conditions of their employment. What the heck does that mean? Let's go to the next slide and find out. So the NLRA says that employees cannot be discriminated or retaliated against if they do several things. If they talk with one or more employees about working conditions, you can't retaliate against them. If they raise concerns about working conditions to you as the employer on behalf of other employees, are we seeing a theme? acting with other employees, acting on behalf of other employees. Number three, if they participate in a concerted or a group refusal to work when the employee has an honest belief that their working conditions are unsafe. Note that I put quotes and I underline this honest belief. And the reason why I did that is because the employee's belief that working conditions are unsafe does not need to be objectively reasonable. It just has to be an honest belief that they genuinely hold. And finally, employees are protected when they join together to talk to the media, believe it or not, about problems in the workplace. Next slide, please. So now that we have a general idea of what the NLRA protects, and again, it protects certain types of group activity on the part of employees, what are some of the risks and penalties that can happen if we violate the NLRA? Well, if an employee believes that they have been retaliated against for participating in those types of protected activities, they can file a charge with the NLRB. And the NLRB is that National Labor Relations Board. That's the federal agency in charge of enforcing the NLRA. The NLRB will then conduct an investigation. And if they want to proceed, the NLRB itself will file an administrative complaint against you, the employer, and there will be an administrative hearing before what we call an administrative law judge, an ALJ for short. And that essentially, even though it's not a lawsuit, it's essentially a mini trial. So it can be very expensive for the employer just to defend these types of things. If the employer is found liable, the NLRB can impose a cease and desist order where they order the employer to stop doing something. They can order the employer to give back pay to employees who have been perhaps suspended or terminated, meaning lost wages. They can force the employer to put the employee back in the position that they were before they were retaliated against, along with some other remedies. So the key takeaway for all of us is that the risks and penalties associated with violating the NLRA can be significant. Next slide, please. So now that we have an idea of the NLRA, one note that I wanted to get into before I got into some practical examples, some real life examples of NLRA issues in the workplace is I wanted to sort of emphasize for everybody, and I believe Jan and Brad brought this up before, is that we expect that under the Biden administration, the NLRB is going to start coming down harder on employers. I think Brad mentioned this with respect to OSHA before. I'll be getting into that again in a little bit. But certainly under the NLRA, we expect that the NLRB is going to start becoming stricter with employers, certainly stricter than the board was under the Trump administration. And just as a recent example, less than a month ago, the NLRB came out with an announcement and they proclaimed to the world that they would begin to vigorously pursue what are called mutual aid and protection cases. And those, again, are the types of cases where employees group together to either aid or protect the group. So they've already announced to everybody, we are on this issue. It's on our radar screen. And for lack of a better way of putting it, we're coming for you. Okay? In the same memo, the NLRB came out and said, look, there are certain things that we consider to just be inherently group activity, inherently concerted. For example, the board came out and said, we consider it to be inherently concerted when employees engage in, with, or on the authority of other employees. We sort of already knew that, right? Or B, when an employee seeks to initiate or induce or to prepare for group action. So they don't even need to be engaging in group action. The NLRB is signaling to us that they consider it to be inherently concerted when employees try to engage in group activity. That's significant. The NLRB did remind us that in order to be protected, an employee's purpose must be for the purpose of changing employer policies and not just for their own personal individual benefit. And that's important. It's about trying to act with or on behalf of other employees as opposed to just acting out of your own personal individual concern. So let's get into some practical real world examples of how these NLRA issues can flesh themselves out in the workplace. Next slide, please. Here are some fun hypotheticals that I have for you. Number one, can I discipline my employee for loudly complaining to a coworker in a common area about a supervisor not wearing a mask? My answer to you, if you haven't figured it out already, is that it would be risky to discipline this employee for complaining, okay? What is this employee doing? As far as the NLRA is concerned, this employee is discussing with a coworker the terms and conditions of their employment. NLRA protected, right? We might be able to counsel the employee that they should not be engaging themselves in the workplace, such as to create a disruption to work, right? Because this employee was loudly complaining in a common area. But I would just caution you to be very, very careful with these types of things. We really can't take any action that could appear to this very employer antagonistic NLRB now, that we are trying to limit or prohibit employees from discussing or even complaining about the terms and conditions of their employment. So it would be risky. Number two, but what if the employee disparages the company by posting about it on Facebook? Risky, right? The employee, what they are doing is they are, again, discussing the terms and conditions of their workplace, meaning that they're complaining to the public about the supervisor not wearing a mask. When it comes to, under the NLRA, when it comes to complaining on social media, one thing the NLRB has told us is that there is a difference between when an employee just engages in a general gripe session on social media and when they are complaining along with other employees or they're complaining on behalf of other employees. So that's the only potential rub here, is that if the social media post makes it abundantly clear that they're only complaining about their own situation, that's one thing. But these are complicated questions, right? These are not black and white answers. There's really no dividing line. One recent example is where employees were sending a text message to a certain supervisor in the company. And the NLRB found out that the employees all sent the same exact text message to the supervisor. And that fact led the NLRB to say, look, it looks like this could potentially be concerted group activity because they all sent the same text message at the same time. So maybe if employees are all posting the same thing on social media at the same time or around the same time, that could be an indication that it's group activity. But the takeaway for you is that, again, number two, risky to discipline the employee. Number three, can I fire an employee for complaining to coworkers because we are requiring vaccinations? This should be a pretty easy one for us, right? Again, this employee is complaining or discussing the terms and conditions of the workplace to another coworker. So it would be risky to terminate that employee. And again, to Jan's presentation, for all we know, that employee could also have a medical issue. So there could be an ADA issue and a reasonable accommodation issue that we have to go through. But even under the NLRA, it would be risky to fire this employee. Number four, can I fire an employee for trying to convince coworkers to refuse work because we are not requiring vaccinations? So this employee is trying to initiate or induce group activity, right? This employee is trying to convince coworkers to refuse work. The NLRB has already told us that they believe that when employees try to initiate group action, when they try to induce group action, it could be inherently concerted, right? And we also know that an employee's belief doesn't need to be reasonable. So even though employers are not right now required to mandate vaccinations, as long as that employee has an honest belief that the workplace is unsafe, their activity is potentially protected as well. So I hate to be the bearer of bad news on all these examples, but again, number four, it would be risky to terminate that employee. Number five, this one might be a little bit different for us. One of my employees has requested to work from home due to COVID. Can I require him to come in? Well, if it's clear that this employee is just asking for himself to work from home and they're not making that ask on behalf of other employees or with other employees, then under the NLRA, you can probably require this person to come to work and discipline them if they don't under the NLRA. But I want to stop there for a second, because remember, in the real world, not just one law applies. There could be others. So for example, does this employee have a medical issue that we might have to provide a reasonable accommodation for? This could be an ADA issue. Outside of the legal issues, has your company issued a policy or a memo that has allowed employees to work from home? How have you allowed other employees to work from home under that policy? We want to avoid discrimination claims here as well. And finally, consider the employee relations aspect of this as well. It's not just all about the law. Is there an employee relations risk of requiring our workers who are telling us that they are concerned right now during the pandemic to come into work? Next slide, please. So takeaways, and this is easy for us, right? The takeaways are: be careful. Be careful when employees are complaining or protesting or refusing to work due to workplace safety concerns, especially if there's any indication at all that that employee is speaking on behalf of other employees or if they've discussed the issue with other employees. Easy advice for you: when you get these issues, stop, drop, and call counsel. Next slide, please. Okay, so we talked about the NLRA. What about OSHA? That's the other big one. Let's talk about OSHA. Next slide, please. We all know what OSHA is. That's the Occupational Safety and Health Act. It's an old law. It applies to essentially all private employers. For those of you who do not know, OSHA requires, just like Brad discussed earlier, it requires all private employers to provide a workplace that's free from essentially dangers, to paraphrase, right? A duty to provide a safe workplace. This year, again, under the Biden administration, OSHA released guidance saying that essentially the easiest way to provide a safe workplace during the COVID pandemic is for employers to implement what they call a COVID-19 prevention program. And those of us who might think that that is a simple thing, I would ask, look at what they say about it. And what they say about it is that it has to include 16 very specific components. I don't have time to go through those components now. I've provided a link for you where all of those components are laid out, where OSHA tells you exactly what they believe that you should include in your COVID-19 prevention program. And one important thing that I did want to point out, because we have been talking about vaccines a lot today, is that one thing OSHA makes clear is that when it comes to putting into place a COVID-19 prevention program, they're saying that as of now, we should not treat vaccinated employees any differently than unvaccinated employees. Meaning, if we're going to require everyone to wear masks inside, which we should be doing right now, we can't say, well, if you've been vaccinated, you can skip that. OSHA's saying that you should not be doing that. We should not be differentiating between vaccinated and unvaccinated employees. They should all be required to do the same things under the COVID-19 prevention program. Next slide, please. So we know that OSHA requires us to provide a safe workplace. What does it also do when we're talking about in the context of employee complaints and protests and refusals to work? In addition to requiring employers to provide a safe workplace, OSHA also provides whistleblower protections. What does that mean? It means that OSHA protects employees who complain about workplace issues to their employers. It prohibits employers from retaliating against those employees. Specifically, OSHA protects employees who file an OSHA complaint, who institute any proceeding under or related to OSHA, who testify or are about to testify in an OSHA-related proceeding, and most importantly for our purposes, it also protects employees who exercise on their own behalf or on behalf of others any right afforded by OSHA. What does that mean for us in the COVID-19 setting? Let's go to the next slide and see. So as far as when it comes to COVID, OSHA prohibits us, again, from discriminating or retaliating against employees for engaging in various types of workplace safety and health activities. Specifically, OSHA says that employers cannot retaliate against employees for raising reasonable concerns about COVID safety. And that's regardless of whether they raise those reasonable concerns about COVID safety to the employer itself, the employer's agents, other employees, governmental agencies, or even to the public through things such as social media. So very, very broad when it comes to OSHA's whistleblower protections. Next slide, please. Also, if it weren't enough, in addition to OSHA requiring employers to provide safe workplaces, and in addition to OSHA providing whistleblower protections to employees who complain about workplace safety issues, OSHA also allows employees to refuse dangerous work. But under OSHA, the standard is a little stricter than the NLRA standard that we discussed before. And under OSHA, 4 things need to be satisfied for an employee to be able to refuse work under OSHA. Number 1, where possible, the employee has to ask the employer to eliminate the danger, and the employer must fail to do so. That's number 1. Number 2, the employer's refusal to work must be made in good faith. What does that mean? That means that they need to genuinely believe that an imminent danger exists. And we can go on, we can have a whole presentation about what is genuine belief, what is an imminent danger, especially under the COVID-19 context, right? We don't have time to go through all of it in detail now. But the important thing for OSHA, when compared with the NLRA, remember the NLRA didn't say that the employee's belief in that there's dangerous work needed to be reasonable. But that's not the case under OSHA. Under OSHA, under number 3, not only does the employee's belief need to be made in good faith, not only do they need to genuinely believe it, but a reasonable person has to agree that there's a real danger of death or serious injury. So under OSHA, there needs to be a reasonableness component, right, to their belief that the work is dangerous. And number 4, finally, there has to be an urgency here. There has to be not enough time due to the urgency to get the issue corrected through something such as an OSHA inspection. So in order to refuse work under OSHA, the test is stricter than the NLRA, but the takeaway that you should be getting from this is, again, stop, drop, and call counsel if you have an employee who's refusing to work because of what they believe to be a dangerous work condition. Next slide, please. So we talked about the fact that OSHA requires us to provide a safe workplace. We talked about how OSHA provides whistleblower protections. And now we just talked about the fact that OSHA allows employees to refuse dangerous work under certain situations. So now what happens if we don't do one of those things? Well, when it comes to the duty to provide a safe workplace, we've probably all heard of an OSHA inspection, right? And the way that's initiated in most cases is an employee is able to file a complaint with OSHA, essentially saying that my employer is not providing a safe workplace. OSHA will then conduct an inspection. And by the way, OSHA under the Biden administration recently announced that they're going to be ramping up inspections. They're going to be transitioning from remote inspections to physical in-person ones again. So essentially, read between the lines, let's get ready for more OSHA inspections. If OSHA conducts their inspection and finds that there was a violation, they can issue a citation against you along with hefty fines, tens of thousands of dollars potentially, depending on the nature of the violation. But what about those whistleblower protections? Well, again, an employee can file a whistleblower complaint with OSHA. Okay, and that whistleblower complaint says, I complained about something that I thought was an unsafe working condition, and my employer retaliated against me. What happens in that process? Well, the first thing that can happen is that it could trigger an OSHA inspection, right, for the underlying unsafe condition. And again, same thing, OSHA would conduct its inspection and potentially fine the company if there's a violation. But as far as the retaliation piece, as far as the whistleblower piece, if OSHA finds that there's reasonable cause to believe that retaliation did take place, well then guess what? The Department of Labor has the right and ability to file a lawsuit against the company in federal court for that retaliation. And if there's liability found in that lawsuit, if it's found that the company messed up, the judge can order the company to provide back pay to the retaliated against employee. It can give the employee brunt pay, other out-of-pocket and pain and suffering damages called compensatory damages. It can punish the company by assessing what are called punitive damages, essentially penalty damages, and also provide injunctive relief, meaning the court can order the company to do certain things like post certain notices, etc. Next slide, please. So let's get to some real life practical examples here of how OSHA can play itself out with these issues in the workplace. Number one, some more fun hypotheticals for us. Number one, can I fire my employee after she complained to us for not having a sufficient COVID prevention program? Well, if it wasn't clear before, it should probably be clear to a lot of us now. This would be risky. It would be risky to fire this employee. Why? Because under OSHA, as far as OSHA is concerned, this employee is complaining about a workplace safety issue, especially if it's true, right? Especially if it's true that you don't have a sufficient COVID prevention program. But I would ask you to stop and think to yourself, even if it's not true, and even if you have a perfect COVID prevention program, are you willing to risk the employee after you fire them? Are you willing to risk them filing an OSHA complaint anyway, and OSHA conducting an inspection and determining for itself whether you have a sufficient COVID prevention program? So again, these answers are not always straight up legal answers. Some of these are practical, real life answers as well. Number two, what if the employee disparages the company by posting about it on Facebook again, right? Well, OSHA, again, we went through this a few slides ago. OSHA specifically says that employees are allowed to raise reasonable workplace safety concerns online through social media. So I know it might sound unbelievable that we can't do anything about this, but it would be very risky to discipline this employee for complaining about a workplace safety issue on social media. Number three, but the employee didn't discuss the issue with coworkers and is only acting on her own behalf. I mean, come on. Well, remember, unlike the NLRA, and the NLRA is all about group activity, right? OSHA is not about group activity. OSHA does not require that the employee needs to be acting on behalf of others or acting as part of a group to be protected. Under OSHA, the biggest question you should be asking is this employee raising a reasonable concern about workplace safety? So again, it would be risky here to discipline this employee, even though they're not acting on behalf of or with other employees. Number four, can I fire an employee for refusing to work because he is generally concerned about COVID? Well, remember, when it comes to refusals to work, there's that four-part test, right? Do they have a genuine belief? Did they raise the issue to the employer first? Did the employer fail to do anything about it? Is it a reasonable belief? And is the situation so urgent that an OSHA inspection would not be adequate? You have to go through those four prongs, right? Whenever you're dealing with a refusal to work context. But all things being considered, if an employee is just generally concerned about COVID and they're not raising some reasonable concern about some workplace safety issue, it's generally not going to be protected under OSHA. But again, I would ask you to not stop there. I would ask you to ask yourself, does this employee have a medical issue for which a reasonable accommodation such as working from home might be required under the ADA? Are they acting on behalf of or with other employees such that they would be protected under the NLRA? What does your policy or memo say? And how have you been implementing that policy or memo with respect to other employees, right? Is there a potential discrimination issue here? And finally, think about the workplace relations issue. Think about the employee relations issue. Next slide, please. Again, takeaways. These should sound pretty familiar, right? Essentially, be very careful. And I would say the first step, based on that recent OSHA guidance that we got, was please, if you haven't done it already, please click that link in the presentation. Look up what OSHA says should be included in your COVID-19 prevention program and begin the process of doing that as soon as you can. Otherwise, continue to regularly monitor and implement current CDC, OSHA, and other local health guidance. Train your employees on and managers on appropriate COVID safety procedures. If you haven't done so already, update your handbooks and policies to require employees to comply with health standards and guidance. Update your anti-retaliation policies to cover workplace safety and health issues. And finally, again, consult with counsel if you have an employee complaining about workplace safety issues or refusing to work for those issues. My final note, next slide please, is just a reminder that in addition to the NLRA and in addition to OSHA, Florida also has its own Whistleblower Act. It's not specific to COVID-19. It's not even specific to health issues, but it could potentially be implicated when we're talking about employees complaining about workplace issues, such as COVID safety issues. And what does the Florida Whistleblower Act say? This covers, by the way, employers with 10 or more employees. And it says you can't retaliate against employees for doing certain things. Specifically, if an employee discloses or threatens to disclose an employer's violation of a law, rule, or regulation, you can't retaliate against the employee. If an employee provides information or testifies regarding an investigation of an employer's alleged violation of a law, rule, or regulation, you can't retaliate. And most importantly, for our purposes, if an employee objects to, all they need to do is object to, or refuse to participate in an employer's violation of a law, rule, or regulation, the Florida Whistleblower Act says you can't prohibit, you cannot retaliate against them. Again, we can spend all day talking about what is a law, rule, or regulation, what constitutes an objection to or a refusal to participate. But the takeaway that I want everybody on the call to understand is these situations are not straightforward. When you get an employee complaining about a workplace safety issue during the pandemic, refusing to work, otherwise protesting, be very careful. So final slide, final takeaway, be careful, stop, drop, and call counsel. Don't think these are black and white situations. They very rarely are, and we can help you walk through all of the interlocking laws on these situations, walk through the facts, and make sure that you're going about these things in the most prudent way possible. Again, thank you. One last topic, John Burgess, our employee benefits specialist. Next slide, please. Our employee benefits specialist. Hello, John. Can you please tell us quickly about the COBRA premium subsidies and employer notice requirements under that new American Rescue Act?
Yes, this is the quick 5-minute version. We do have a more comprehensive client alert coming out, hopefully this week, so there'll be more information on that. But yeah, my name's John Burgess. I do all sorts of employee benefits, 401k plans, health plans, executive compensation, including equity plans, and of course ESOPs, which are one of my favorite things. But topic of the day today is the new COBRA subsidy that just came out in the Rescue Act. Just real quickly, some of the basic requirements. We did get some additional guidance from the Department of Labor from this about a week and a half ago, so that's helped us out a little bit, along with some model notices I'll talk about. But this subsidy essentially gives employees the right to re-elect into COBRA starting as of April 1st, so this is retroactive, and not have to pay the normal COBRA cost, which is typically 102% of the total cost that is shared between the employer and the employee. So from the employee's perspective, typically very expensive, and this gives them a chance to do it at no cost to them. Now, what happens is that the employer is going to be picking up the cost of the coverage and then claiming that through federal tax credits through their FICA tax with the government. So in the end, the government pays for it, but the employer has a lot of responsibilities here administratively. And so let's talk about who's eligible for the subsidy first. Number one, it's anybody who had an involuntary termination of employment and their COBRA eligibility period, even if they didn't elect COBRA in the first place, would extend at any point in time. That 18-month period is typically what it is, would extend into the April 1st, 2021 to September 30th, 2021 time period. So in theory, you could have people who terminated back in late 2019, their 18-month COBRA period may run until this May or this June, and so they would be eligible to pick up this COBRA subsidy. And you have to reach out to all these people, and there's a notice that is going to be that is out there. The DOL has a model notice that you'll send to these people. Most likely your COBRA administrator will be doing that. So a lot of this work isn't going to be in your hands, but I think the big challenge for a lot of employers is going to be, you can identify all the people who terminated during that time period, but figuring out which one of those, who was involuntary versus who was voluntary is something that your records may not always reflect. It never, for most purposes, it never really mattered until now. And so you may need to go back and look and figure out why the employee left. Maybe you could look at, some notes that you had as they had an exit interview. But the notification only has to go to people who were involuntarily terminated. If for some reason you're not sure, it's probably better just to send it out to people who are in sort of a case where you don't know exactly what it was. So the subsidy starts as of April 1st. They have a chance to elect back to retroactive to April 1st, but their 18-month COBRA period does not get extended past the normal 18-month time period. So let's say you had somebody who terminated December 2019. COBRA would have started for them on January 1, 2020. The 18-month period runs up to June 30th, 2021. So even though the subsidy period extends for another 3 months after that, once they hit that 18 months, they're done. They can't go on COBRA and even pay for it, unless your plan for some reason allows them to do that, which is obviously pretty rare. So that's the eligible group. And again, the employer has to send a notification out to all these people who they identify as having terminated involuntarily and are still eligible for COBRA coverage. Now, there is a notice that the DOL did provide. There may be a few employer-specific things that you need to plug in, some employee-specific things, but I wouldn't stray too far from the language of that notice. They gave it to you for a reason. You don't want to go in and do additional things or tell them additional ideas that they don't need to already have in there. So my advice, just stick with what the content of the notification is, and you should be good there. So assuming that they enroll, the COBRA subsidy, even though they can come back into COBRA, the subsidy ends at any point in time in which they are eligible for some other employer-sponsored group coverage. So maybe they got a new job and they're now eligible for that plan. Even if they don't take it and they're still without coverage, they can't go back and take the subsidy. And unfortunately, we're just going to have to rely on a lot of the employees in order to do this. So make sure that you have good records or some sort of certification from the employee saying that, yeah, I have not become eligible for other group coverage as I'm taking the subsidy. Final note here is that once we get up to September and we're gonna have a notification to get employees off of the subsidy, because the subsidy at this point in time is going to run out September 30th. Again, who knows? Things have been extended so many times in the COVID world, it could happen again. But for now, there is going to be a notification requirement that you have to provide to them as their eligibility for the COBRA subsidy runs out. And the first notification, by the way, is going to be due to these employees. You have to send it out by the end of May. So basically right before Memorial Day, you've got to get those things out the door to people. And again, your COBRA administrators I'm sure if you have outsourced that, is going to be doing a lot of that work for you. They probably have the information that you need. It's just because they've done COBRA notices for these people anyway as they left. And so they'll be sending them the second notice, and they may just need information about who was involuntary versus who was involuntary. Quick note about people who are not subject to COBRA. Remember, COBRA on the federal level only applies when you have 20 or more employees, but Florida has a mini COBRA statute, which applies to everybody else who is on a fully funded insurance plan. There were some FAQs from the DOL that came out with that other guidance about a week and a half ago, which said that if somebody is taking COBRA or mini COBRA under a state statute, and Florida is not alone with this type of statute, they would be eligible for the subsidy. So you can't claim a subsidy for them if they're under coverage, but this doesn't necessarily change the rules about their election period. So most state statutes tend to follow the COBRA rules about when somebody has to elect, but the guidance from the DOL said that this does not change any of that. So we may need some additional changes on a state level in order for people who would have been on mini COBRA to go back and do the re-election period like you definitely have under federal COBRA. I haven't heard any noise about that happening on a state level, but again, that's just something else we'll be watching out for as we progress here and this thing really starts to get ramped up. So like I said, any additional questions that you have, we do have a client alert coming out very shortly. And of course, you can contact us and we'll be happy to help you with any specific questions that you have. So that is COBRA subsidies in 5 or 6 minutes.
Thanks, John. I think we're going to kick it back to Jan to close us out now.
Yep, great job, everyone. John, thank you for pitching in at the end, and we look forward to the client alert to help explain that process. And again, I know you're there for any questions clients may have. We managed to get in under the deadline by 4 minutes. I think that's a record for us. I don't see any questions in the chat. So if you have follow-up questions, you can always email me or anyone else on the panel. Again, we have HR and CLE credit approved. Katie will send that out after to everyone, so you can go ahead and get the credit for that. She also, I think, will be sending a copy of the materials, so you can click that link that Chris was talking about to go get the Department of Labor's guidance. Again, I will renew my request. Any feedback that anyone can give us, we really appreciate. We do want to make sure that this is successful and helpful to you. And so, again, any suggestions, improvements, please send them along. If you want to do it anonymously, you can just send it to Katie and she will screen out who you are and send it to me, and we'll try to make this better. So again, thank you everyone for your time. Thank you, Brad, Chris, and John for putting this on. And everyone stay safe out there, and we'll see everyone soon. Thank you.
Thanks, everybody.